Now I ask the council in 125141, State of Kansas versus Williams Nunez, to please come forward.
May it please the court, Williams Nunez appears through counsel Jacob Nowak at the Appellate Defender Office. Chief Justice, may I please request 3 minutes of time for
3
rebuttal?
minutes. 3 minutes is reserved, yes.
Thank you. Case comes on before the court on petition for review from the Court of Appeals decision following Williams Nunez's conviction of rape and a sentence imposed. Ordinarily, for severity level 1 crimes, the maximum post-release sentence allowed is 36 months. However, for sexually violent crimes, that period of post-release may be increased to lifetime post-release supervision upon a finding that the defendant was 18 years of age or older at the time the offense was committed. But here, the state did not include that age element in its charging document. The jury was not instructed on that age element in its jury instructions. Therefore, it did not make that finding as a part of its verdict, and the state has conceded it presented no evidence of Williams' age at trial.
Can I jump in there? And if there was age in the, or excuse me, if there was evidence in the record of age, would you agree that this error is amenable to a harmlessness analysis?
I think it would depend on what precisely that evidence was.
Well, the whether or not the error is harmless would depend on that evidence, but just in terms of a standard of review, we
Yes,
could,
whether or not it would be
in
subject-
theory, just in terms of what the law says, it could be subject to a harmlessness analysis.
Yes, that's consistent with this court's case law on the matter. Again, here the state has conceded that there was no evidence presented at trial. And I think this case highlights why courts should avoid cutting corners around constitutional rights, because we've got several unpublished Court of Appeals decisions and now one published Court of Appeals decision that have applied an Apprendi admission exception to get around this right when people have pled to sexually violent crimes without waiving their right to a jury trial finding on this age element. And it was on the backs of those cases that we've arrived here, where Williams did not enter a plea. He did not enter an elemental stipulation. He took his case to trial and held the state to its burden to prove every essential element beyond a reasonable doubt. There's nothing Williams could have done more to preserve his right to a jury trial. That didn't matter to the Court of Appeals because in their view, he admitted his age and waived his right to a jury trial on that element when he filled out a financial affidavit for appointed counsel. For anyone following along at home that doesn't know what that is, everyone is entitled in the United States to counsel to assist them in their defense. If they cannot afford an attorney, the state must appoint one for them. The financial affidavit is how someone proves to the court that they do not have the assets to afford an attorney. And on those financial affidavits, it generally requires you to either fill out your date of birth or your age, and that is what Williams did. Court of Appeals held that that was an admission and therefore a functional waiver of his right to trial on that element, which means the Court of Appeals position is that the state of Kansas can and does require indigent defendants to waive their right to trial, at least on certain elements, when they invoke their constitutional right to counsel. That decision cannot stand. It flies directly in the face of the doctrine of unconstitutional conditions. Government cannot condition the receipt of a government benefit upon the waiver of a constitutional right, and it certainly cannot make individuals choose between invoking one right over the other. You get all of them. The United States Supreme Court discussed that in United States v. Simmons, where it found it intolerable that someone would have to choose between the Fourth and Fifth Amendment rights. And if that is applicable, then it cannot apply in this case. Because when you compare the Fourth Amendment rights to the Sixth Amendment rights, really the Fourth Amendment rights are slightly lesser rights. We would not apply an exclusionary rule and debate its merits to a Sixth Amendment right. We would never apply a good faith exception to a Sixth Amendment rights, because the right to counsel and the right to trial are fundamental, they're essential, they're generally structural. And if the Gideon court were here today, think they'd be mortified that we're even having this discussion in the year 2024.
The age of 18, either 18 or older or under 18, is not an element. It doesn't have anything to do with the crime that was charged, that was prosecuted. But what you're suggesting is, and I think the law supports this, is that in order to impose the post-release supervision that the state is seeking, it requires an age proof. How does that come into a jury trial? What's the necessity of proving that, or how would that happen? I'm trying to think functionally. When it's not required to prove the crime, but only one small portion of the, and I'm not saying it's not significant, but one small portion of the sentence, which is post-release supervision, it's necessary. How would that happen? How would the state go about it? How would the court go about instructing?
Well, the framework's there. It's the same exact way they do it with any Jessica's Law conviction, any Jessica's Law trial. That is only that age element of 18 or older in Jessica's Law cases is only relevant to the sentence that's ultimately imposed. It's not relevant to the elements of rape. It's essentially a sentence enhancer or a greater offense, however the court would like to look at it. But we've done this with Jessica's Law cases from this court's decision in State v. Bellow. And what the state does is they include it in the jury instructions. They include it in the charging documents. Even though it's not your traditional element of this offense, it goes to the sentence enhancement. So they just do the same exact thing and bring in the evidence the same exact way, I suppose, that they attempt to do so in Jessica's Law cases. Not what happened here. And frankly, it's not happening in a lot of cases. Usually those are resolved by pleas, but it's an ongoing issue.
And so I'm tracking your argument well so far, and the conflict that's created or the seemingly conditions that are placed on the exercise of the two rights with the financial affidavit. So let's talk about the other evidence. And my bottom line question is, what sort of documentary evidence, what characteristic, what does it require to constitute an admission that would satisfy the Apprendi-Blakely standards? And I don't know if that moves you on to the PSI or the departure motions. Are you suggesting at the end of the day that to be a valid admission, it has to be knowing and informed in conjunction, not just simply an admission to the factual component, but there has to be some, characteristic of reliability in addition to that?
Yeah, my suggestion would be the court set out the framework for jury trial waivers. An admission has to be a jury trial waiver. Because what it's doing, or at least what the Court of Appeals believes it is doing, is relieving the state of its burden to prove an element beyond a reasonable doubt. This court wrestled with this a little bit in Johnson on what exactly do we do with the stipulation, and arrived at the same point that I'm essentially advocating for here today. And I think the point is that we need to stop worrying about how we label it. Doesn't matter if it's in a plea, stipulation, waiver, admission. If it relieves the state of that burden, it is a waiver. It's a waiver of the right to a jury trial. And in order to be accepted, it needs to be explained to the defendant on the record by the court. Then they need to do an inquiry to make sure it is knowingly and voluntarily waived. Without that, it's nothing. And
You're pausing there. I want to bring you back to kind of where you started. And I understand your claim that the state has conceded this issue, but I'm going to ask about it anyway. And that is whether or not there was sufficient, I guess it's really, sufficiency is the wrong legal category, but there was evidence in the record from which a jury could/would have concluded that your client was 18 years old at the time of the crime. And I want to draw your attention specifically to the testimony that at the time of the crime, Nunez and his girlfriend had a 4-year-old daughter, which would have made, I guess just by the math, that means Nunez, for him to have been under 18 at the time of the crime, he would have had to have been 13 years old at the time his daughter was born. That enough for us to conclude that a jury would have found him to be 18 years old or older?
Happy to answer your question. I am going to push back a little bit. As you know, the state has conceded that issue. This is not like Sheets where the state conceded an issue and then petitioned it after the fact.
I understand that, but when we have a record, I mean, I'm not sure that parties' concessions matter when we have a record that's in front of us that we can read ourselves.
My general concern is that raising arguments on behalf of one of the parties seems to fall within the four corners of the advocates. And I'm not sure that the court should be wading into those waters.
Well, I'm just looking at the record and trying to discern how to apply the test, the harmlessness test. Would a jury have concluded? And I think, I mean, I understand your pushback, but the record is what it is, and this is what it says.
Based on the strong language that this court has used in its prior cases, overwhelming and undisputed evidence, no. People can have children at the age of 13. That's not going to be overwhelming and undisputed evidence of this case. There's not evidence of his age because the state didn't present evidence because they didn't probably know that they needed to. They probably misread the statutes, and that's why our record does not have overwhelming and undisputed evidence of Williams's age at the jury trial. It wasn't proven to the jury. They weren't given an opportunity to make that decision.
I'm still unclear about how we satisfy you. Back to, how would you instruct, you know, we're not supposed to have special questions in criminal cases, so what would be the jury instruction that's applicable to a particular problem with post-release supervision? I mean, how do you get at that? And the reason I'm confused is because in, what is it, State v. Reyna, where age was an element, that it was okay if finding, as long as we could find within the evidence on a constitutional standard, harmless error, that the jury would have found that age. I'm just, I don't understand the mechanics. How you establish 18 or over when it's not an element of the offense.
State charges it as an element of the offense. The state puts it in its charging document, thereby giving notice to Williams Nunez that it is intending to seek a sentence of lifetime post-release supervision. And when it drafts its jury instructions, the jury instructions on rape will end, or somewhere included there, include, you must find that he was over the age of 18 in there. PIC's not absolute. We can modify PIC.
I don't care about that. I'm just really trying to figure out what we do.
That's my answer to what we do. And I think that's exactly what we do in Jessica's law cases. So again, I think the parallels there are uncanny. We would do the exact same thing in Jessica's law cases.
And is the remedy here, would you not default back to the 60-month post-release as opposed to the 36 months that I maybe think you were advocating for? I mean,
Right, no,
or does
sorry.
the error infect both components of the post-release statute, that over 18, it's, you know, X, under 18, it's Y?
Right, so the problem is the standard for a severity level 1 is 36 months. If you're under 18, if there's a finding that you're under 18, it's 60 months.
Right.
If there's a finding that you're over the age of 18, it's lifetime. Problem with the 60 months is there's no finding by the jury that he was under the age of 18. In criminal law, things can just be unproven. That's sort of how sufficiency of the evidence works. This element is completely unproven, so we have to present or impose the statutory maximum sentence based upon what elements.
Well,
were in
I
fact
mean, he has to either be under 18 or over 18, right?
not in criminal law. Again, there is no fact.
I mean, I do
until there's-
understand your technical argument that there's no evidence for that, but
If we're talking about
doesn't it
in
strike
reality,
you that beggars common sense?
find it to be the same though as in Jessica's law cases. I mean, every Jessica's law defendant is either under 18 or over 18, and yet we don't just allow courts to impose a lifetime sentence on them. That element is eliminated in Jessica's law cases and pleas all the time as a form of mitigation to put the defendant on the grid, either as a severity level 1 or a severity level 3 sentence. If William Nunez is unsuccessful, that would mean that a court could show up to those sentencings and say, I know everybody thought that we were going to do a severity level 1 or severity level 3 sentence, but I found an admission somewhere in this record. I'm sentencing him to a hard 25. I don't think this court would allow that. Judge, Chief Justice, I see I'm over time. I apologize if I'm well over time. If there are any outstanding questions, I'll take them, but I will be back for rebuttal.
Good morning. Basically, the bottom line here is that Blakely and Booker tell us that factual admissions by a defendant are an exception to the Prendy rule. The present case, the state did concede that there was no direct evidence presented during the jury trial portion of this case of the defendant's age. The only evidence of his age came from his admissions, application for court-appointed counsel for sentence departure, and then during his testimony in support of his motion for sentence departure, he admitted in all 3 of those instances that he was over the age of 18. Also like to point out that there's nowhere in the record below or in this appeal where Mr. Nunez contends or any evidence suggests that he was less than 18 when he committed the offenses.
So I want to ask a little bit about those, what you characterize as admissions. I mean, everyone knows he was over 18. I mean, everyone knows here at least, let's just say. But your opposing counsel's argument is you can't count those as admissions. I mean, he was being truthful on forms that the government required in order for him to obtain his constitutional rights. It's not really an admission in the sense of an evidentiary admission.
Arguably, I think it'd be a stretch to say that he knew when he filled out that application for court-appointed counsel that when he wrote 32 years of age on or his date of birth on that form,
I mean,
that he knew it was
Yeah,
going to
for
be used
example,
against him later.
the
but-
application for court-appointed counsel cannot be conditioned upon the defendant admitting he's guilty.
Right,
I mean, obviously, right?
correct.
So why
We're not
should it
arguing.
be able to be conditioned on a defendant admitting an element of a subsequent punishment?
And
That's his argument. I would like to hear your best response as to why we can count that.
we don't even have to get to that though, factually in this case, because he later, with the assistance of counsel, admitted his age during the sentencing arguments in support of his departure motion. So we have no evidence in the record that the court relied solely on that statement or that fact in his application for court-appointed counsel in finding that he was 18 years of age or older.
I thought I understood, and my understanding could be very wrong, is that the documents were the affidavit for counsel, the PSI report, and a pre-sentence motion. It sounded like you said there was actually some discussion in open court about his age. Did I mishear you?
No, I didn't mean to.
You're referring to these same documents then?
Yes, and I don't even know that I referenced the PSI in the brief in this particular case, but I think this case can be distinguished from the other cases decided previously before the Court of Appeals, because in this case, Mr. Nunez testified. He testified under oath as to his age, support of his motion.
That's what I was trying to get. So there is, in other words, there is a
The-
transcript of a discussion of his age in open court, in the record.
Yes.
As opposed to documents.
Yes. Okay.
And I'm just trying to struggle with those other documents that you just ran through. and maybe even statements of the defendant himself. In the context of a stipulation to an element, we require, a knowing informed waiver. And to convert or transform that group of evidence that you're relying on here into the category of an admission under Blakely Apprendi, why don't we require the same thing?
Oh, in my reading of the cases, I didn't read them to be so restrictive that it required a specific waiver. The cases simply state that a defendant can waive Apprendi. What happened here? Cases which a defendant may enter a,
How do they wait? What's the waiver? Maybe I'm just misunderstanding it factually.
well, I'm likening it to a situation where a defendant might plead guilty and then stipulate to specific facts that form the basis for an enhancement.
Subsequent to a waiver.
A waiver of the jury trial right,
Correct.
at the time of the plea. I don't know that that extends to sentencing phase, though. My experience, it never has, and I didn't read any cases that extended it. But
The US Supreme Court has extended that for that protection for jury trials to sentencing enhancements, right? Not just limiting it to elements of an offense, but also enhancements.
I don't know. I'm not thinking of a case that specifically says so. We feel that because he made that waiver, that the evidence is there.
Well, wait, again, getting back, what waiver was ever, this was a jury trial, correct? There was no
Yes.
waiver ever entered into.
Well, did not, I guess it wasn't a specific waiver, but he did not require a jury to find that he was 18 or older because he presented that evidence himself to the court.
Who is he? Are you
Mr.
saying the
Nunez.
defendant?
Yes.
Why would the defendant present that evidence? That's not in his self-interest.
Defendants waive their right against self-incrimination all the time and make statements that are that incriminate them during trial, so.
Yes, they do, but you're not saying that it's his obligation to prove he's not
No.
over 18.
So here's my issue. Okay, so the law in Kansas, when you're kind of looking at all the cases, they seem to limit admissions under Apprendi and Blakely to those made as on the basis of a guilty plea. So where you're actually saying, okay, I'm pleading guilty and I'm waiving my rights, right? And so you're waiving your jury trial rights. Okay, so they're that key component. And now this case presents it outside of a jury trial waiver, which I don't know that we have a case like that. And, the financial affidavit causes constitutional concerns. The PSI has its own concerns, but when you're looking at the pre-sentence motion for departure being an admission, that waives a jury trial right, because that's what we're talking about in the context of Blakely. You can't just say it's an admission. I mean, it's an admission waiving a jury trial right. It was filed after a jury trial verdict. There was no jury trial waiver, and it was filed for a completely independent purpose. So even if he did state his age at sentencing, maybe it was some kind of admission that he was over 18 or older. But where do we find the jury trial waiver, which is at the core of Blakely and Apprendi? That's the part I'm not getting.
I haven't read any cases that would indicate to the contrary that the admission has to be in that phase of the trial. Nothing required him to state his age. He did it with the assistance of counsel at the time of the,
But I'm talking about the jury trial waiver. Would you agree that Blakely and Apprendi have to do with waiving a jury trial? Okay, and that all the cases that, that we're all relying on, all are in the context of guilty pleas where the defendant is waiving a jury trial. Do you have any cases where that's not the case?
not specifically, the only other cases that I ran across dealt with departure factors and whether or not the defendant had specifically stipulated to the facts that supported the fact or aggravating factors for departure. So
But there's cases, aggravating factors, statutes provide that you have a whole, another jury trial on that unless you waive it, right?
correct. But we
That
can't,
kind of supports what I'm saying.
But as I understand, you are saying that you are agreeing there was no evidence to the jury. So are you saying that we are really in a neither-like land where we're looking to see whether or not there was a missing element, an element that the jury didn't find, but we're applying a neither-type test to the record to see if there is evidence of the age? And you're saying that his testimony under oath at the departure motion fits that neither substitute
yes,
finding? Is that where you think we're at, or are we some other procedural status?
quite possibly, yes, I think we are.
And I don't know that in neither have we required waivers to apply neither in that line of cases.
But I think the only case that kind of comes close to your position is, as previously mentioned, is State v. Reyna. But in Reyna, what happened there was an admission before the jury during trial, not only as to his date of birth, but also his age. That was uncontested, and that was before the jury, which has allowed us, I think, to get to neither and the exception. We don't have anything close here, do
No,
we?
we don't. Actually, no, you're correct. Other questions?
Briefly as it pertains, or may it please the court, just briefly as it pertains to the departure testimony, that can't be relied upon to satisfy any sort of harmlessness test or be considered as a admission. Certainly not in Kansas law. I'm not familiar with any federal case that's allowed for it to be done at the sentencing hearing for the first time, the waiver, but there wasn't a waiver in this case to begin with. And also our case law says we do not allow special verdicts. Once our verdict was in, which happened at the end close of trial, his verdict was final, as long with the constitutional statutory maximum of his sentence. It
So
can't be
that
increased.
leads directly to my question, which is, what do you think would happen if the state made an effort to introduce testimony or evidence of the defendant's age and it was met with a relevance objection? Wouldn't that relevance objection be granted? Because the defendant's age has nothing whatsoever to do with any of the elements of the crime.
At the trial here,
In any trial, like here or in the abstract.
well, I think it pertains to the trial here because it wasn't charged as an element of the crime. My guess
But it's
is
not an element of the crime, right?
it can become one if it is charged that way because it's an essential element of the offense. It's, again, we charge these elements in Jessica's Law cases, even though they're not within the four corners of the crime of rape. It's a sentence enhancer, and they still wind up in the jury instructions because that's what's constitutionally required when you
So
are
you're-
seeking a sentence enhancement.
So your answer to my question is that if it was objected to on relevance grounds, the argument would be, well, the case law allows us to do this because it's a sentence enhancer.
My assumption would, my presumption would be that the state would come back with, we're allowed to amend the complaint up until the time where it is submitted to the jury. We will amend that to include this, to include the sentence enhancer at that point, and then you have a jury trial on it.
Okay.
They might be kept out for other reasons, but relevance could be defeated by simply amending the complaint before it goes to the jury.
This
And
gets-
what,
Go ahead.
I was just gonna ask, but what do you do in a case like this where you've, I understand the procedure when you're starting fresh or amending, but now that we've gone through this, we've had sentencing, how do you address this at a remand?
With directions to impose the constitutional maximum sentence, which is 36 months
Okay.
post-release.
So there's no opportunity then to, yeah,
That,
okay.
that's overgone, yes.
Still struggling with my first questions that you and I answered about, which is how to do this. Your answer sounded to me like you were adding an 18 or element to the crime itself. Can't do that, right?
Don't see why not.
Well, so if, let's just say the jury thought he wasn't 18, he's not innocent.
State's free to charge a lesser in the alternative.
Let me ask it this way then. What's wrong using a harmless error test based upon what was presented to the jury, just kind of like a Reyna situation? And in this case, we would just all agree that it doesn't meet that constitutional harmless error standard. So you would get your result, but we would be agreeing that the test is harmless error, constitutional harmless error.
I think it would have to be constitutional or harmless because the
I
state
don't have a problem with
conceded.
constitutional harmless error because of the Apprendi
Sure.
problem. But I'm just saying that's the standard. It's just, it didn't work this time for the state, from the state's perspective.
I think the state's concession is dispositive on it being harmless. Yes.
I understand that this court has said for I know of, that we don't allow special verdicts. And I think that is in criminal cases. And I think that is based in part upon just concerns about making sure the jury applies all of the rights that attach in a criminal trial, presumptions of innocence, et cetera. But do some of those things apply when we're talking about a sentence enhancement? Do we need to take a step back and look at whether allowing a special verdict in this very narrow area is the appropriate way to get to presenting this to the jury?
Might be one reason for why this court has consistently held there are no special verdicts. The other is there's just flat out no jurisdiction for them. Trial court's jurisdiction comes from the Constitution, which thereby limits it to what is set forth in our statutes. There is no statutory mechanism for a special verdict. Trial courts do not have jurisdiction to conduct them.
I don't think that's our case law. Our jurisdiction is over the criminal trial, not over questions asked in the criminal trial. I'm not sure I understand because this is a sentencing over which courts are given jurisdiction. Not sure I'm following your argument as to why we wouldn't have jurisdiction to apply a criminal sentencing statute in a criminal case.
It's jurisdiction to impanel a second jury.
I'm not even saying a second jury.
Well, it'd have to be a jury trial because he has a,
Why couldn't it be asked in the first, as a special question
at his
Your
original
jury.
trial as opposed to.
I'm sorry, now
including it.
I
Okay.
understand.
I
what
thought we
you're
were talking about overruling Obregon.
I'm
Completely.
just talking about using a special verdict form for the original jury. I'm sorry. We were talking past each other.
I have less of a problem with it being as a special question in the same verdict packet for the jury. The court's case law obviously has criticized that and found it harmless when it's done it in that mechanisms in some instances before, because we don't allow for special questions for the jury. Personally, I have less of a problem with it being done as an element and then a special question, provided that they are still instructed that it must be proven beyond a reasonable doubt, and that the state has the burden, and that can never shift to the defense. I'm fairly certain the protections constitutionally would still be fine for the defendant in that instance. I think it is cleaner to just put it within the elements of the crime, and that's what this court's current case law directs courts to do. Your Honor, I will stand for any outstanding questions, but seeing none.
I do have
Oh.
one more question. I'm trying to distinguish what the chief is saying about neither and a missing element from what I'm saying about the waiver of a jury trial. So I looked and, I mean, I don't think the neither issue is briefed. Was that briefed?
I don't believe we briefed neither.
Right, I didn't think so either. So help me understand what the difference is there as far as you see it. Because I'm not, you're clearly not seeing it as a missing element, right?
I think the state charged essentially a lesser, but if you wanted to consider it as a missing element, then I suppose neither addresses that in a similar context to what this court has found to be harmless or not in the Jessica's Law cases when the age of 18 was not submitted to the jury. If it's overwhelming and undisputed, which is not what we have here today, maybe it could be considered harmless. We don't have that here today. Ask that this court reverse the Court of Appeals and remand for resentencing. Thank you.